SM Algeria.
Yes, it's going.
Please, the court, we are as we were before, except now we are joined by Mr. Gill and Mr. Alawalia for the first intervener at the Coram Children's Legal Centre, and by Mr. O'Neill and Ms. Robinson for the Ayr Centre. My lady, my lords, I'm in your hands as to how we proceed. As you know, we have two issues before you.
We've got two matters to deal with, jurisdiction being logically the first, and then we've got Article 2. So,
yes. May I suggest respectfully that we start with Article 2.2, because in relation to Article 2.2 there is no jurisdiction point. We accept.
Oh yes, that's absolutely true. Yes, if Article 2.2 applies, there is no jurisdiction problem. Yes, indeed. Yes, we have got that point.
So my preference is to begin with Article 2.2, not least because the jurisdiction point, especially on the EU compatibility side, is very detailed. Yeah. And in the short time available, I'm anxious to make sure that my time is sufficiently spent on Article 2.2.
Well,
court's content.
You should take your own course, after all. You have limited time, and you must make the use that you think is going to be best of it.
So on the question of Article 2.2, the issue is whether SM falls to be treated as a direct descendant of her sponsor within the meaning of Article 2.2c of the Citizenship Directive, as given effect by Regulation 7.1b of the Immigration EEA Regulations 2006. And it's common ground that EU law requires that adopted children be treated as direct descendants for this purpose. And our first submission is that the EU has left it to the member states to decide what is meant by adoption in this context, provided that the national measures respect EU fundamental rights and international law obligations relating to the welfare of children. Second submission is that the UK rules respect EU fundamental rights and the UK's international obligations. If I could ask you to turn first to the directive, and that's in the main authorities bundle, Joint Authorities, tab 9. And it's MS page 673. And Article 2.2c is at MS page 684. And you see that family member is defined as the spouse, the partner with whom the union citizen has contracted a registered partnership, and then for our purposes, C, the direct descendants who are under the age of 21 or are dependents, and those of the spouse or partner as defined in point B. And there is no further definition of the term direct descendant, but as I said, it's common ground that, although not said expressly, it extends in principle to a person who is a descendant by adoption. But as I said in my opening, what is meant by adoption is exclusively a matter for national law. And in this respect, I could ask you to turn to the next...
How do you substantiate that statement? You've got authority for that statement, have you?
Well, I have 2 points on that. The first is that the EU has a competence in relation to this matter, which it has not exercised. So I think it's common ground. No one has suggested that the EU has legislated for adoption. But I accept, as I said at the beginning, that in relation to the measures which member states adopt in relation to adoption, member states are constrained to respect fundamental EU law principles. So, for example, in the area of EU law, member states must respect charter rights, which include rights of children under the charter. That's common ground. My short point is that the EU has not legislated to define adoption. That is a matter for the member states.
But it would be very surprising if the EU, or it might be thought surprising if the EU took the view that an institution such as Kafala would have different impacts on free movement of workers according to which state you were in. That would be quite surprising.
From a free movement perspective, yes. But if the EU were to legislate in relation to what adoption meant, which I think is my lady's point, the EU would set out minimum standards. which would have to be satisfied by all member states. And since the EU member states are themselves bound by the UNCRC, the Convention for the Rights of the Child, one would expect the EU measures, if they were adopted, to reflect those. And then whatever type of adoption or quasi-adoption that was advanced by people such as Kafala would have to satisfy those conditions.
In other words, if the EU addressed the question, you anticipate that they would set minimum standards and, to use probably an apt expression, the margin of appreciation available to the states could not transgress the minimum standards.
Indeed. That's how, if the EU were to adopt a harmonising measure in this field, which it has not done, but if it were to.
But what does that mean? The failure to adopt a harmonising measure, does that mean that the margin of appreciation is limitless?
No, it's greater because adoption is a matter for member states, but as I said, it's not limitless because in deciding what is adoption in national law, member states must at the same time respect the provisions of EU law that may be affected by the measures that the state adopts, in particular measures under the Charter, rights under the Charter. So the member states' powers are not completely unfettered. They have to respect those other EU law rights when they legislate in the area of adoption.
And this is all assuming that the expression doesn't have an EU meaning.
Yes, but since it's not referred to expressly in the directive, it's less likely, I say, to have an autonomous EU law meaning. The EU has not referred to it or made provision for it. We have accepted, based on our obligations under the Charter, which are also obligations under EU law, that adopted children, adopted within the meaning of national law, must be treated as direct descendants for the purposes of Article 2.2c.
Yeah. At some point you're going to come on to the Commission's guidance.
Yes, I will, which is just guidance, as I said the last time we were here. And in fact, that's what I will come on to now. That's behind tab 10 in the same volume. As I said, this is not binding, and the Secretary of State doesn't agree with all of it. But on the particular issue before this court, we note paragraph 212.
Can you give me a...
The MS melody is,
724.
724.
I've got so many different electronic bundles here, it's completely impossible.
Share your...
Well, somebody should have put them all together, shouldn't they? At least all the ones that we had from the last hearing, and then just the extra one for this hearing.
It would have made our preparation a lot easier, yes.
Yes, well...
And our understanding.
For which I apologise.
So if we take up a lot of your time with trying to navigate through these different, my Lord and I, you'll forgive us, won't you?
Absolutely.
Anyway, let's get on. This is guidance.
Yes, so paragraph 212, family members in direct line. And you will see here that what's being discussed are family members and other beneficiaries beside paragraph 2.1. And what's said at the top of that paragraph 212 on page 4 is, without prejudice to issues related to recognition of decisions of national authorities, the notion of direct relatives in the descending and ascending lines extends to adoptive relationships or minors in custody of a permanent legal guardian. Pausing there, my submission is that when the Commission refers to without prejudice to issues related to recognition of decisions of national authorities, what they're saying is that they're recognising there that adoption is a matter for the member states. What adoptions are recognised is a matter for the national authorities.
And equally, whether a minor is in the custody of a permanent legal guardian.
Yes, that's what the Commission envisages being covered by Article 2.2. Of course, there's no express provision for that in the directive, and that is also subject to national authorities recognising those matters as sufficient to constitute direct descendancy. Mm-hmm. So, before we... and then we turn...
And what do you make of the next sentence? That foster children who are in the temporary custody of foster parents may have rights, presumably, and this is still dealing with Article 2.
Yes, and that's why I said that the Secretary of State doesn't agree with all of this.
Yeah. So if the Secretary of State's view is in conflict with the Commission's, that may have implications for whether there is whether the interpretation of this directive can be said to be quite clear.
I understand that, my Lord. I mean, we should, of course, recall that the reference to foster children and foster parents does not arise in the facts of this case. So if there were to be a question referred on that issue, it would be hypothetical, and the court wouldn't, as you know, the court doesn't accept, and certainly doesn't like accepting hypothetical questions. The question of whether foster children are covered by Article 2.2 doesn't arise in this case. But we all note that it's said there that in the Commission's view they do.
It does look, doesn't it, as if they're talking there about Article 2, although they say simply may have rights under the directive, depending on the strength of the ties, etc. It's located in a section which seems to be dealing with Article 2. Is that right?
My Lord, I agree.
Is there any sign of them having actually addressed the question?
No, all we can deduce is what my Lord has deduced, which is that it's in the 2.2 section. Yeah. It's not in the other family member section. So the Commission envisages, it seems, foster children with temporary custody may be treated as direct descendants under Article 2.
But what does the next sentence mean? There's no restriction as to the degree of relatedness.
Well, foster children may or may not be related to the...
If it's foster children, yes, of course.
I adopt my lady's suggestion, but the truthful answer is we have no idea what that means. And but again, ordinarily, if that were an issue in the case, that might suggest a reference ought to be made. But it's not an issue in this case. Yeah. We're not concerned with degrees of relatedness. But it is just guidance. It's a communication. If you see its status, it's a communication from the Commission to the Parliament and Council. This is on the very first page, on guidance for better transposition and application of Directive 2004/38. And my Lords will see that in these sections that we're discussing, the Commission cites no authority for the particular more controversial points which they make.
Well, it cites authority for the inclusion of adoption.
Yes, but that's common ground.
That authority being Article 8 of the ECHR.
Yes.
So that might be a steer to the direction of, well, who would be recognised as having family life together under Article 8 of the ECHR. It might be a steer in that direction.
It might, my lady, but we would say not coterminous, because, of course, Article 8 is given a very broad interpretation, whereas the EU legislature has divided family life in this directive into an inner core, which is 2.2, and then a broader area, which is 3.2. Article 8 is not coterminous with Article 2.2.
If it was Article 8, and that was enough, would it catch all the Article 3 people as well?
Might do. The Air Centre submission is that Article 3.2 goes further than Article 8.
Yes.
So that's not entirely clear, but it would certainly go far beyond the limited group of people defined in the exhaustively defined group in Article 2.2.
Well, we're talking about children.
Yes.
Parent-child.
Yes.
Or quasi-parent-child relationships here.
Yes.
So the breadth of Article 8 relating to other types of relationship is neither here nor there. We're talking about children.
Yes. And in relation to children, may I turn to the international obligations? Because when one looks at the potential breadth of the scope of Article 2.2, which the appellants and the others contend, the very, very broad scope which they contend, one must bear in mind the international obligations. They are critical in this area. And if I could ask the Court to turn to Volume 1, Tab 1, which is the United Nations Convention. And, it's in the Joint Authorities, and it's MS 427. And the Court sees on MS 428, Article 3, that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authority, or legislative bodies, the best interests of the child shall be a primary consideration. And the court turns to Article 21, which is on MS page 432. One sees the article of the Convention which addresses adoption. And this is a very important article for the purpose of my case. All parties rely on it, and it's necessary to go through it very carefully since it establishes the minimum standards which all parties and the EU, all states parties in the EU must respect in relation to inter-country adoptions. States parties that recognise or permit the system of adoption shall ensure that the best interest of the child shall be the paramount consideration, and they shall ensure that the adoption of a child is authorised only by competent authorities who determine in accordance with applicable law and procedure and on the basis of all pertinent and reliable information, that the adoption is permissible in view of the child's status concerning parents, relatives and legal guardians, and that, if required, the persons concerned shall have given their informed consent to the adoption on the basis of such counselling as may be necessary. B, recognise that inter-country adoption may be considered as an alternative means of child's care if the child cannot be placed in a foster or an adoptive family or cannot in any suitable manner be cared for in the child's country of origin. Very important point, that question of care in the country of origin must be considered first. And then C, and I place particular reliance on this, ensure that the child concerned by inter-country adoption enjoys safeguards and standards equivalent to those existing in the case of national adoption.
Now, are you going to take us to Article 20, paragraph 3?
Absolutely. And I must take you to that because it's relied on against me. And so if you turn back over to MS 431, you see Article 20. And Article 20 provides that a child temporarily or permanently deprived of his or her family environment, or in whose own best interests cannot be allowed to remain in that environment, shall be entitled to special protection and assistance provided by the state. And then to 3, such care could include, inter alia, foster placement, kafala of Islamic law, adoption, or, if necessary, placement in suitable institutions for the care of children. And then when considering solutions, due regard should be paid to the desirability of continuity in a child's upbringing and to the child's ethnic, religious, cultural and linguistic background. Now, the first point to make about this is that it is not addressing inter-country adoption. Adoption is mentioned as one of a range of solutions that can be provided in the case of children temporarily or permanently deprived of their family environment. And when asked what are the minimum standards applicable in the case of adoption, we must turn to Article 21. Article 21 is the key article in relation to adoption. The reference to kafala in Article 23 is a reference to one of a number of solutions, one of which is adoption and others which are quite different from adoption, which could be used to protect children who are entitled to this form of special protection. But it does not bear the weight that my friends place on it, because they submit that the simple reference to kafala in that context means, it seems, that one can ignore, for the purposes of the protection that must be applied in the UK, the minimum requirements in Article 21. That's not the case. And
if you have a child that's in a kafala relationship, and that's how it's receiving the care required by Article 20, do you say that it's consistent with the state's duty to act in the best interests of the child to decline to recognise that relationship under Article 2 of the directive?
It depends on the question of what form of recognition is sought. If what is sought is recognition akin to adoption, so that it's treated as an adoption with the benefits that accrue to adoption, then the state is required to insist on compliance with the requirements in Article 21. But in order
Of course,
to...
Article 20 also refers to adoption.
Yes,
It's one of the methods
yes, it does.
which it puts beside kafala. And the question is whether, if you've got kafala, which is not adoption, but nevertheless has features
Yes.
similar to adoption, which of these two articles is the dominant article?
Well, my idea, it is relevant for these purposes that Article 20 is referring to the state, and in this context, since there's no reference to inter-country adoption, we assume it's referring to the home state.
Not necessarily.
Not necessarily, but...
Wherever the child is.
Yes, but my idea, if you're asking which is to be given predominance in the area of inter-country adoption, Article 21 is the detailed article that addresses it and refers expressly to inter-country adoption. Article 20 makes no such reference.
It sounds as if you want us to regard kafala as adoption for one purpose, but not for another.
No, my lady. I'm not saying kafala can be regarded as adoption in the sense that we understand it in this country. I'm saying that I recognise that kafala is one of the solutions which are solutions other than adoption, envisaged in the particular circumstances in Article 20. The concern of the Secretary of State is not the label that's given to the arrangement, but the Secretary's concern is that the requirements in Article 21, which are implemented in Section 66 of the Act, are properly respected. That is our concern. And just because these are critical requirements, and my learned friends in the appeal and their interventions don't address how these requirements are to be respected, adopting the tests which they advance, which they say should apply to kafala in this context. And so it's important that I take you through these international norms, since they are vital in understanding our obligations as a state and also the EU's obligations. And the Hague Convention is the next instrument which I wish to take you. That's behind tab 3 in the same authorities bundle. Now, I appreciate that Algeria is not a party to the Hague Convention, but this is instructive as to what international norms consider necessary in this context. And this is MS page 467. And the objects of the convention are set out there under Article 1. And then, for our purposes, under Article 4, requirements for inter-country adoptions. This is what is considered necessary. An adoption within the scope of the convention shall take place only if the competent authorities of the state of origin have established that the child is adoptable and have determined, after possibilities for placement of the child within the state of origin have been given due consideration, that an inter-country adoption is in the child's best interests, to ensure that the persons, institutions and authorities whose consent is necessary have in particular been counselled as may be necessary and duly informed of the effects of their consent, in particular whether or not an adoption will result in the termination of the legal relationship between the child and his or her family of origin. And in Article 5, an adoption within the scope of the convention shall take place only if the competent authorities of the receiving state have determined that the prospective adoptive parents are eligible and suited to adopt, and have ensured that the prospective adoptive parents have been counselled as may be necessary. These are vital requirements for the purpose of the child's welfare, and they are set out in the Hague Convention. And you have seen in our submissions that the Council of Europe, in view of its role as policing compliance with the provisions of the Convention that deal with the rights of children, has issued a particular warning, because this area of inter-country adoption is fraught with risk for children. And we see the warning that the Council of Europe has issued in Volume 4 of the Joint Authorities Bundle. It's behind tab 51.
51?
51, my lord, yes. It's MS 1851. It's entitled International Adoption Respecting Children's Rights, and paragraph 1, the purpose of international adoption, I'm reading about halfway through the paragraph, must be to provide children with a mother and a father in a way that respects their rights, not to enable foreign parents to satisfy their wish for a child at any price. There can be no right to a child. And then 3, it wishes to alert European public opinion to the fact that, sadly, international adoption can lead to the disregard of children's rights and that it does not necessarily serve their best interests. And then at 4, in 1993, the international community adopts a set of ethical standards and rules in the form of the Hague Convention, in which the guiding principle is that of subsidiarity, that is to say, international adoption may be considered only if domestic solutions are not available. And evidence, this is not a theoretical concern, because evidence of that disregard appears in this very case. There are uncontested findings of fact in the first-tier tribunal. Which I need to take you to before we get into the submissions. And that's in the core volume, MS 154. One five four.
Thank you.
And if you turn to, that's the first page of the FTT's determination. If you turn to page MS 161, you see the analysis by the FTT of the process that the appellant maintains was sufficient for the purposes of kafala in Algeria, which he seeks recognition in these proceedings. And these are uncontested findings of fact. The FTT found that at paragraph 32, an order transferring legal custody was made in Algeria. However, the social worker in Algeria had never met the sponsor, never spoken with him, and there was nothing to suggest the social worker has ever checked on the child since the making of the order. The sponsor's evidence is that the judge was more concerned that financially the appellant could look after the child. Little, if anything, was said about the welfare and emotional needs of the child or plans for her upbringing. No checks appeared to have been made in the background of either parent. For the UK-based sponsor, there are no police reports. Ms. Brown, the independent social worker, never sought to obtain any evidence from the sponsor's doctor. And if you turn over to paragraph 34, you see there was no rigorous assessment in Algeria. There was no evidence before me of the sponsor of Ms. Meduni's qualifications as a psychologist. And then Ms. Brown, the independent social worker, offered evidence which is dismissed. And then at 35, because we're concerned here really with the process in Algeria, no reason has been given by the sponsor for not approaching the authorities in the UK with a view to obtaining a certificate of eligibility to adopt. He has sought to bypass the normal requirements by adopting abroad without even speaking to social workers in the UK. I find that this is an issue of choice. It was a choice they made having learned that it was easier to adopt custody of a child in Algeria than it would have been in the United Kingdom. And that ease appears to be because there are limited or no checks and a perfunctory court procedure.
Would the Secretary of State's attitude be any different if there had been a rigorous assessment in Algeria?
It might be, yes.
Or is it just a jury point?
No, it's not a jury point, because after the last hearing, when my lady put to me, and we'll come to this question of de facto adoptions, what the solution could be, and we'll come to questions of indirect discrimination, we've had an opportunity to take instructions and consider the point internally. And the point that my clients, the Secretary of State and the various departments whose responsibility it is to look after children, come back to is that they have yet to see a structured, rigorous way in which these kafala adoptions can be presented to them. They have yet to see an application which demonstrates in these non-convention, non-designated countries a sufficiently rigorous process. They have real concerns about the process. So there's as I said at the beginning, the concern here is that the process is consistent with our international obligations.
But you were asked whether it would make a difference if the findings had been in completely contrary sense, if they'd been that there had been a thoroughly a thorough investigation and so on. Now, there's a procedure, isn't there, for recognition?
My Lord, yes.
You're going to come to
I'm going to come to that, absolutely, because it's...
I mean, all I'm asking is there a procedure by which somebody can judge whether in the individual case the process has been satisfactory, or is it necessary for us to say either a process of this kind is always within 2.2, or it never is?
My Lord, the answer is no. That I will come to this, but
yeah.
It's the question of recognition of adoptions at common law. And we'll come to that because it's one of the accepted routes whereby adoptions can be recognised. And that happens in situations where it's possible to satisfy the English court that the adoption which is sought to be recognised has been made in a country with equivalent standards and protection. And we'll come to that when we look at the MN India case. But the answer is, I took you to those facts for two reasons. First, not as a jury point, but to demonstrate the risks, the real risks which exist and why the Secretary takes such a prudent position. And secondly, to prompt my next point, which is that if an applicant can show that he has adopted in a jurisdiction which has rigorous protection equivalent to that in England, then it may be possible for that adoption to be recognised at common law under one of the accepted routes. And that's why I need now, I think, to turn to the national rules and Section 66 of the Adoption Act, which is in the first volume of authorities behind tab 12.
Page, please.
Sorry, forgive me, MS 747. And this provides for what adoption means in domestic law. So in this chapter, adoption means, and you see A and B, which aren't relevant for our purposes, then C, an adoption effected under the law of a convention country outside the British Islands and certified in pursuance of Article 23.1 of the Convention. And that convention is defined in Section 144, which is in page MS 753 as the Hague Convention. Protection of children and cooperation, respective inter-country adoption. And then at D, 66.1D, an overseas adoption. An overseas adoption is defined in Section 87, which is in MS page 752. And overseas adoptions are adoptions of a description specified in an order made by the Secretary of State, effect under the law of a country or territory designated by the Secretary of State. So,
that always was the case.
That was always.
Yeah. It's convention adoptions are the addition, aren't they?
Yes. And then at E, 66.1E, this is the point that I was discussing with my Lord a moment ago, an adoption recognised by the law of England and Wales and effected under the law of any other country. And this is the provision that permits adoptions at common law. And the approach under adoptions at common law is that the English court will recognise a foreign adoption from a non-convention and non-designated country if satisfied that equivalent standards and protections for the welfare of children exist and have been respected, and there's no question of evading more rigorous standards under the Hague Convention. Now,
where do we get that from?
That is what I'm instructed is the approach of the court. There are obviously cases.
There must be cases.
There are cases.
Could we be told what they are?
Yes, of course. Sorry. I can get them sent. I apologise for not having them here.
Well, if you make a statement of law, which you've just done,
yes,
it's standard practice, at least in this court, to provide authority for it.
So, that is how adoption is defined. But under the UK rules, there are a number of avenues by which an EU citizen may bring a child into the UK following his adoption abroad or for the purposes of adoption in the UK. Those are summarised by my Lord Justice, as he was then, Lord Justice Wilson, in MN India, and that's in the second volume behind tab 21. Turn to that now, please. Page MS 977. And at para 13, which is on MS page 980, see the reference to it's necessary to analysis of the argument under Article 8 to notice the 4 different avenues for entry to the UK provided by the rules in respect of a child adopted or intended to be adopted. Supposing there the question here was if someone who fell outside those 4 avenues had a separate freestanding right under Article 8 of the Convention to enter the UK for the purpose of adoption in any event. But we're concerned here with just examining these avenues. And before we go to them, I wish to stress that these are concerned with entry to the UK, not with the status of the child following entry. Once in the UK, only children satisfying Section 66 are treated as adopted. So we'll go to the 4 routes, and the rules are referred to at para 14, but if we could just skip ahead to the bottom paragraph on page 981.
And are the routes now the same as they were in 2008?
Yes.
It's under completely different authority because it will be under Appendix FM.
Yes, the labels have changed, but the routes are the same. So the first of the 4 avenues is the bottom paragraph on page 981, and it's convenient to focus on the requirement at little 6a, the first of the 4 avenues, as one which requires the child should have been adopted in accordance with a decision taken by the competent authority or court in the first country, being a country whose adoption orders are recognised by the UK. And those last words obviously...
Wouldn't it be a lot easier? I mean, obviously we need to come on to what my Lord later said about all of this, but in order to understand the roots, wouldn't it have been easier to refer us to the current law about this?
My lady, yes. And I'm sure those references...
It's just I'm having great difficulty in picking this out of this text here.
I mean, it's summarised by the Court of Appeal in this case.
That might be easier, mightn't it?
A summary has been... an elegantly drafted summary is provided by my Lord Justice's laws in the judgment below.
Well, if you could perhaps give us the reference to that and then get on with what your argument is.
Well, then I shan't take you through then all of these 4 avenues verbatim. My learned junior will give me the reference to the judgment below, which summarises these.
Thank you.
But the point I'm making is that on the facts, none of these routes are available to the sponsors of the appellant in this case.
The judgment below begins at MS 137.
But now coming on to the controversial point that Milady put to me last time, which is because one of the... Actually, before we leave it, I will ask you to look at the requirements for de facto adoption. De facto adoption and the requirements for that are set out in paragraph 15, MS 982. Because this was suggested at the previous hearing as a potential solution to the problem in this case, or even not on the facts of this case, but the problem more generally. So paragraph 15 is a reference to the second avenue being under paragraph 310 6b of the rules de facto adoption. The requirements of that are set out at rule 309A, also on page 982. And these are the entirety of the requirements for de facto adoption. That for the time immediately preceding the making of the application for entry clearance, the adoptive parent or parents have been living abroad for at least a period of time equal to the first period mentioned in B1 below, that's 18 months, and must have cared for the child for at least a period of time equal to the second period material in that subparagraph, that's 12 months. And then the second requirement, during the time abroad, the adoptive parent or parents have lived together for the minimum period of 18 months, of which the 12 months immediately preceding have been spent living together with the child. And then 2, have assumed the role of the child's parents since the beginning of the 18-month period, so that there has been a genuine transfer of parental responsibility. That is it, for the purpose of demonstrating de facto adoption in terms of the substantive requirements. Now, the reference to the Court of Appeal judgment is at the summary of MN India is at para 21 of that judgment.
Thank you.
Now, as I said, it was put to me at the previous hearing that this de facto adoption might be a solution, particularly since its looser formulation might avoid conflicting with religious or cultural sensibilities. And as I said a moment ago, since the hearing, I have taken instructions, since that had been it was a new point that was put to us. I've taken instructions from the relevant departments of government, those, as I said, whose responsibility it is to protect children. And the clear answer is that the de facto adoption here is a basis for entry only. Once in the UK, it is for the adults to apply according to one of the routes specified in Section 66 of the 2002 Act if they wish to adopt the child formally.
Well, of course.
Yeah.
Absolutely, of course. It doesn't necessarily answer the question to what is meant by a direct descendant in Article 2.2.
Well, my submission, lady, is that it means it includes adoption, but adoption is defined by the UK. And the question is our definition of adoption consistent with EU and international law? That's the short point. But my point, I have to deal also with the case put to me by the appellants. And to treat the conditions in IR 309A as sufficient in themselves to create a relationship of adoption would place the UK in breach of its international obligations.
Forgive me, but you seem to be focusing entirely on adoption, and the issue that is particularly raised by the Commission's guidance is whether that may not be too narrow a way of looking at it. You know, that even if you have a relationship which admittedly cannot be regarded as adoption, conceivably, such as foster parents or guardianship, you may nevertheless have a relationship of a child living as a member of the household of an adult couple, they exercising parental rights and responsibilities in respect of the child, and for the purposes of the directive, the question arising whether that should be sufficient.
Maud, I see the point, but the question is, how is that to work? Because to treat a child as a direct descendant under Article 2.2 is to confer very significant rights and recognition on that child. That is treated as equivalent to direct descendant or a biological child of parents, which is what adoption is. And that's appropriate in the case of adoption because of the very rigorous checks that are imposed in order to make sure that a child has been properly adopted. If a looser formulation is used for the purpose of qualifying for Article 2.2, that puts the rights of children at risk because it would allow someone to take custody of a child in a third country in a situation that does not comply with the Convention, and then arrive in England and say this is a child is akin to an adopted child, and therefore no further scrutiny is required. And we have all the rights under the directive which children of parents have. And adoption, Article 2.2 is narrowly drawn. It can be extended to adopted children because they are akin to biological children under our law. But the looser formulations which have been advanced by my own friends and by the Commission in that communication are insufficiently rigorous to comply with our international obligations.
I mean, from our point of view, a direct descendant certainly includes an adopted child. And one would have guessed that our fellow Europeans would take a similar view, but they may not. It may be that there is an autonomous meaning to the words direct descendant, and if so, we must take cognizance of it. But apart from the Commission's guidance, which is said in the introduction to it to be subject to the case law, where in the case law do we find anything indicating a definition of direct descendant as wide as is now contended for? And indeed, if you're going to come back or on to the Advocate General Bott in Rahman, I mean, it's quite clear, though he was focusing on 3.2, that he thought that 2.2 was very narrowly confined, I think, to what he called the nuclear family.
Yes. Yes, indeed.
Yes.
And I will come to that because one of the points made against me is that this approach that we have adopted, and which I'm contending, is contrary to EU law. And I absolutely do rely on what the Advocate General said. He said that 2.2 is relatively restrictive and confined to the nuclear family. Now, I appreciate that's the Advocate General's opinion, but there is no authority for the very broad contention which I face. And I appreciate the more narrow points being put to me by my Lord, but in this appeal, I must address the arguments of the appellants also. And I wish to turn, if I may, to what the appellant and the CCLC contend should be the approach for defining those who should be treated as direct descendants under Article 2.2. And if I may take you to the grounds of appeal, which are in MS 24.
Paragraph?
Paragraph 32. And the appellant contends that applying the principles of interpretation of EU law, the term descendant in Article 2.1c includes not only the biological or Hague Convention adopted child, but also a child of the legal guardians or child of the family where the biological parents' whereabouts are not known. There's no examination as to by whom not known or how that's to be assessed. Where there's been a genuine transfer of parental responsibility, again, there's no discussion as to how that is to be assessed. Where the child is abandoned and has taken on the couple's surname under due process in Algeria, which does not recognise adoptions. But of course, there is a real concern about the due process in a third country that is not a convention or designated state. It requires particular evidence to satisfy the English court at common law that standards are equivalent. It's not enough simply to say due process in Algeria. And then finally, the point is made that Algerian legal process for conferring legal guardianship on parents of abandoned children is recognised as a special feature under the UN Convention on the Rights of the Child. And we've seen what Article 23 says about that, but it doesn't, in my submission, address inter-country adoption, and it doesn't override the minimum requirements in Article 21 of that convention.
And before we leave the grounds of appeal, we might just flick back to paragraph 25, Mr. Kennelly, where Mr. de Mello makes a very frank, and in my view, a very frank and realistic concession. Even though the consequence of treating a person like her as a direct descendant would be likely to put member states in breach of their obligations under international instruments, this doesn't affect the interpretation.
My Lord, yes. I mean, I didn't take you to that because we've addressed it in writing. In my submission, that is with respect to hopeless submission. And on the contrary, the idea that an autonomous concept of EU law could override international law in this context cannot be right. EU law is subject, and expressly so, to the international conventions for the protection of rights of children. And that, in fact, is what the Commission says itself in its own communication. But it's not only the appellant. The intervener, the CCLC, also makes a submission, which you need to see in the supplementary bill. SSMS 82.
Is this in the new bundle? Or?
Yes, it is. So the page number is SSMS 82. And at paragraph 32, one sees the definition which they contend. They say that the proper interpretation of the directive is that all children of EU nationals fall within the definition of family members of Article 2.2, irrespective of whether they are biological children or children formally adopted under the national laws, or children who are adopted in the broad sense under kafala or similar arrangements of guardianship or permanent care, or children who are de facto treated as the children in the permanent care of an EU national exercising the freedom of movement and residence rights within the EU. In some circumstances, depending on the evidence, the definition may also include children who are in the temporary care of the EU national concerned. In my submission, that is far too broad, and for which there is absolutely no authority. That is an untenable submission. And as I say, far from being required by EU or international law, such a broad and vague interpretation, if adopted by this court or indeed by my clients, would violate our obligations because they disregard the safeguards and obligations established by the Convention and the Hague Convention. My Lords, you've seen in neither of those formulations is there any reference to the need to ensure that, for example, taking the kafala in Algeria as an example, that there's been a rigorous assessment of the suitability of the sponsors, or that the child concerned enjoys safeguards and protections equivalent to those provided for national country adoptions, which is the express requirement under Article 21C.
If that were the correct formulation, then presumably children who'd been bought would be included.
Absolutely. And again, with respect, and in fairness to the intervener, before I
I'm sure nobody thinks that.
No one thinks that. I'm sure they don't think that. But I do raise concerns about the way in which that's been formulated, because in relation to the point I've just made about the fact that there's no reference to what checks need to be done, all the CCLC says, and I quote, is that questions of evidence and questions as to the recognition of decisions of national authorities in non-EU countries may arise. Now, they don't may arise, they are required to arise. But that is all they say about how this test is supposed to comply with Article 21 of the Convention. But of course, on the CCLC's case, when they talk about checking evidence, what they mean is that the UK authorities will check the rudimentary formal requirements which have been satisfied or not in Algeria. That is what's meant. And the particular reasons advanced by the CCLC in support of its interpretation don't take the matter any further. And here I come to my Lord Wilson's point about the Abbey General bot in Raman. Because the interpretation of Article 2.2 adopted by the CCLC has no support in the language of the directive, in the travaux préparatoires, or in the very few cases which have touched on Article 3.2 in CJEU. And in particular, I refer to the statement by the Advocate General Bott, which has been referred to by my Lord, referring to the relatively restricted scope of Article 2.2. I wasn't proposing to take you back to Raman since we went through it in detail at the last hearing.
Well, just remind us of the statement to which my Lord has referred. Just helps the train of thought to have a note that's got a reference.
And Lundgren will dig out the particular paragraph. So the second point made by the CCLC is that barriers to free movement will arise if a broad view, and I'm quoting, of the definition of family members is not taken. Now, the starting point is that the directive itself adopts a limited definition for family member under Article 2.2. That's inherent in the directive. The broader definition appears in Article 3.2.
I think I was referring to paragraphs 52 and 57 of the Advocate General's opinion, which is at MS 1598 and 1599.
That's very kind of you, thank you.
So the first point is the directive itself is relatively restricted. But my second point is that the approach to adoption in the United Kingdom is not so restrictive as to be a barrier to the free movement of people. There are, as I said, several different ways of entering the UK in order to adopt or for the purpose of adoption. And under Section 66, the child may be adopted, resident secured, under the approach in that section, which is not limited to Hague Convention designated countries, as I've explained this morning. And it's true, however, that the process in the United Kingdom is rigorous and involves delays. But adoption should be understood as a serious affair that properly involves multiple examinations and interviews. And a responsible parent who wishes to adopt should not be deterred from exercising their free movement rights by such a process. It's necessarily the case. And if there is any deterrent effect, it is, in my submission, objectively justifiable in view of the very important interest of the child involved. The third point made by the CCLC is that any approach other than the one for which they contend would give rise to discrimination as between children on various grounds, including race, nationality, national origins, and ethnicity. Now, the first point here is that the allegation of discrimination is very vague and unparticularised. That what I've described to you there is as far as it goes. There's no question of direct discrimination. But as regards indirect discrimination, the point was put to me by my lady at the last hearing that for religious reasons, the approach under Section 66 may be a deterrent. But my answer to that is, what is the Secretary of State to do? To treat what the appellant describes as the arrangement in Algeria is akin to an adoption, which is for what the appellant and the CCLC contend, would violate international law. And it's inconceivable that EU law would require the Secretary to do so. My answer, which doesn't apply to the facts of this case, is that, as I said to my Lord, there is a route whereby adoptions can be recognised as common law, and I apologise for not having the authorities describe the approach of the courts in that, which we shall supply to my Lord as quickly as we can. But that is an approach which allows foreign, non-conventional and non-designated country adoptions to be recognised in England.
Yes, but if, in fact, and obviously I don't know, but if, in fact, there is a religious objection to a concept such as adoption, but nevertheless these children are in the permanent care of the people looking after them, whom they regard as their parents, doesn't that create a problem, an obstacle to free movement? If, for example, instead of this little girl being brought or attempted to be brought into this country from Algeria, she had first been taken to France. We're, after all, talking about French nationals here, aren't we? And then the French nationals had wanted to exercise their rights of free movement. What would the attitude of the Secretary of State be in those circumstances? Would the Secretary of State say, no, irrespective of the fact that you have been allowed by the French authorities to treat this little girl as your own daughter, we're not going to let you bring her into this country? Now, I'm not saying that you're wrong to say that. All I'm saying is, isn't that an obstacle to free movement? And isn't it also indirectly discriminatory against people with a religious objection to the concept of adoption?
My first point is, of course, none of that arises in this case.
But it could so easily have done.
It could have, but it's very important to remember that that's a hypothetical question that has not arisen here, but I will answer it. In principle, one can see, yes, that there could be a potential obstacle to free movement in that situation. And if such a situation arose and was presented to the Secretary of State, then the Secretary of State would have to take it into account and have to develop a solution within the scope of national law to deal with it. But no such situation has arisen. Now, the Secretary of State's compliance to EU law is a developing thing. And if such a situation arose, then the Department would have to examine it and examine how they comply with their EU law obligations in order to facilitate it. But that has not happened. And if that situation is itself a deterrent, then in my submission, or indeed indirectly discriminatory, it is objectively justifiable. Because the rigorous and strict approach of the Secretary of State to this issue of Article 2.2 and adoption is justified because of the very serious risk to children if a looser formulation is adopted. And just pausing there, one of the important aspects of adoption, which makes it suitable to be treated as direct descendancy, akin to direct descendancy, is that under our system, an adopted child breaks his or her links with the former family, the birth family.
Yes, and that is the source of the objection.
I understand. But
to adoption as we understand it.
Indeed.
And indeed, not all European countries understand adoption in the precise sense that we do. It doesn't, and nor did we for a long, long time. It was, I think, the 75 Act that completely assimilated the rights of adopted children to those of biological children. So,
but yes, I understand. But that approach which the UK has adopted, it has done so in order to produce a rigorous scheme for the protection of children, and it is the UK's approach to adoption which we say is permitted by EU law, because it is not defined by EU law, and member states are given a margin of appreciation as to how they deal with adoption in their legal systems.
I don't think you can say that on the facts of this case there's no restriction of free movement. And the case concerns a French citizen who's working in the UK, whose wife and child are unable to join him in the UK because the Home Office won't let them in. It's agreed in the Statement of Facts that the little girl is a member of both parents' household and is dependent on them, regards them as her parents, they regard her as their daughter. Now, in that situation, it's idle to pretend that there's no interference with free movement arising from the enforced separation of the father and his wife and child.
My first answer to that is there were routes available to the father and to the family to adopt the child according to the UK's system.
yes, but we've just been putting to you the fact that they can't do that for religious reasons.
Well, the evidence on that in this case is very thin, but I take the point.
Well, let's assume that.
That's a reason.
That is one of the reasons why this is a point of law of general public import.
Indeed. And we've addressed it in our submissions in that way. But my point is that if that is a deterrent, if that is a restriction, it is objectively justified for the reasons that I gave. That the UK has developed what it considers the best way of securing a rigorous system for protecting children. And there are avenues available, including common law adoptions, which can be used.
Hang on, what would be the solution? Just supposing, which doesn't seem to be this case, but just supposing you had parents of this nationality, so EU nationals, they have a religious objection to adoption of the kind as we understand it. But entirely bona fide, they want to make a home for a child who has been, let us suppose, for the sake of argument, placed in their care by authorities in a non-convention country in a way which is jolly close to adoption because it involves a complete transfer of parental responsibility, but it doesn't eliminate whatever biological or hereditary links there may have been, and it doesn't offend the religious susceptibilities. Supposing that that is what has been done, I know you say it isn't this case, but supposing it has been done, and it has been, and it is possible to demonstrate that it has been done with proper care for the to avoid trafficking, exploitation, purchase, unsuitable parents whose track record is very worrying. In other words, supposing there are more or less equivalent safeguards to those which are required by the Hague Convention for adoption, properly so called, what would be the route by which such a child could be admitted to this country? You say not Tutu because she's not a direct descendant, because there's a religious objection to her being a direct descendant. So what is she?
Well, she could be admitted to this, potentially admitted to this country,
yes,
by way of a de facto adoption. But what the Secretary will not do then...
You could call it a de facto adoption, could you?
For a purpose of entry. But she will not be treated as a...
We're talking EU law here, not the immigration rules, which don't apply. Let's just remember that.
Under EU law, there's no bar to her entering the... Actually, under Article 2.2 or Article 3.2, there would be no right under EU law for her to enter.
If you're right, she'd be 3-2, wouldn't she?
No.
Why not?
Because if you recall, my primary submission is that for a child in her position, it's Article 2.2 or nothing. Article 3.2 is not designed to accommodate children who we say ought to be adopted. They're not. Article 3.2 does not contemplate children in that position. So to be clear on my lady's point, under EU law, based on the adoption rules that we have, there will be no EU law right to enter. There will be a domestic law right to enter. But there
won't be a domestic law right to enter because Appendix FM doesn't apply.
Quite separate from that, there is, under the immigration rules, the scope for a de facto entry under a de facto adoption.
Well, sorry.
Unless I'm
Do the immigration rules apply to people coming for EU nationals? Or EEA nationals?
I'm sure you're right, but I've certainly understood.
I'm not sure I'm right. I'm asking the question. You're supposed to know the answer to it.
Well, I certainly don't. So I've asked my clients because I had understood that she was entitled to enter as a de facto, but I would be corrected.
Oh, well, of course, she is not an EU national, but
yes,
we're talking about the rights of entry associated with being an EU national.
Forgive me, my lady. Then I'm sorry. I misunderstood. I'm talking about a child in her position who is not an EU national, but whose parent might be. She is entitled to enter under de facto adoption. She can live here, but not as an adopted child unless she goes through the proper processes under our domestic law. And I think Molly's point is an EU child couldn't apply for entry. That's obviously not this case or anything like it, but I'll take instructions on that point. I'm concerned here with
Rather depends on what you mean by an EU child as well.
Yes.
Yep.
I'm discussing here children in the same position as the appellant. In her position, I understand she could enter but not have any rights under Article 2.2 unless she goes through the adoption process. And I'm told an EU national can still make an application under the immigration rules. No authority. That single sentence. I will see if I can.
I would love to know the answer to that. That's why I was asking. Thank you.
So I think to answer my Lord's point, if, as contrary to what I'm saying, there is a restriction, despite the fact that there are routes available and ways to do it, I say it is objectively justified. That's my point.
Thank you.
Now, the final point that the CCLC makes is that they argue that if a national remedy exists for Catholic children under Article 8 of the Convention, there's no basis for saying there shouldn't be a remedy under EU law, and that Catholic children should come under Article 2.2 or 3.2. Now, in my submission, that's a misplaced argument because in this case, the appellant's case under Article 8 was dismissed the first-tier tribunal. And that was accepted by the upper tribunal, and the Court of Appeal said it was unappealed and unappealable. There's no question in this case of having a remedy, a separate remedy under Article 8, but not under the directive. But as I said earlier, in any event, Article 8 isn't coterminous with Article 2.2. And I rely for that on the submissions I made earlier, drawing from the language of Article 2.2, the recitals 5 and 6, and what Advocate General Bott said in the Rahman case.
What Advocate General Bott said in the Rahman case is I wonder if he may not be placing rather more weight on it than it merits. It's MS 1599. It was referred to paragraph 57. And the Advocate General is comparing the wording of Article 3.2 of a directive with a provision in another directive concerned with family reunification. And he says, whereas under our directive, the member states, quote, shall facilitate, close quotes, entry and residence for members of the family of a union citizen not falling under the definition of nuclear family, then the comparison is with the other directive. So the emphasis is obviously on the words nuclear family, and presumably what he's referring to when he says the definition of nuclear family is the definition contained in Article 2.
Yes.
2.2. Well, he's not focusing on the question whether it might go beyond blood relatives and adopted children to extend to other sorts of relationship.
Well, my Lord, what he is saying, and if you look at paragraph 52,
yep.
And he's doing no more, really, than echoing what the recitals of the directive make clear. Mm-hmm. If you look at the middle of 52 between F and G, he says it's clear that Article 2.2 and 3.2 draw a distinction within the family of the union between the closest members who have an actual and automatic right to entry, yep, and the more distant family members who do not enjoy an individual right of entry.
Yeah.
Well, that's obvious.
Indeed. The point is, though, what it is showing, which is clear from the language anyway, is that Article 2.2 is not intended to have an incredibly expansive meaning.
Well, nobody's suggesting that it is.
Well, my Lord, if you look at the definition that the appellant and the CLC advance, it would have a very broad meaning, contrary, I say, to the plain language of the directive and also for the advocate of the advocate.
Thank you.
Well, my Lord, those are my submissions on Article 2.2. I have half an hour left, I think. On the Sala point on jurisdiction. So I shall turn to that now. So here I shall begin with the legislative background and then address first the question of domestic law construction and then turn to what is required by EU law. And here, since you've just been looking at it, you have to keep the directive open, because plainly, in order to understand the domestic regulations, you need to see the EU instrument which they implement. And if you could turn back again to the directive which is behind tab 9. And if you could read at MS 675 and 676, recitals 5 and 6, which I've just referred in the other context. I shan't read them to you, not least because I'm sure you've read them now several times. And if you turn then to Article 2 at MS 683 and 684, recall, again I shan't read it, a difference in language, which again we've looked at already, adopted by the EU legislature in Article 2.2 and Article 3. Significantly, I say, in Article 3.2 at MS 685, and quite unlike the right under Article 2.2, the right of extended family members in 3.2 is subject to national legislation. The obligation is on host member states, in accordance with national legislation, to facilitate entry and residence for the following persons, who are then defined below. Staying in the same directive, one sees that because family member is defined in Article 2.2, it is actually a definition of family member. Family member means is what it says. So later on in the directive, when you see reference to family member, I say that means family member as defined in Article 2.2.
I imagine that's common ground, isn't it?
Well, maybe no, because there are actually two places where
Sorry.
where it's not, and I shall take you to those. In Article 8.5e.
But, I mean, it's very unfortunate that the draftsman of this, at 3.2, has talked about any other family member not falling under the definition, because that raises the question, what family members are you talking about? Yeah. And it may be when we get onto the regulation, we see the English draftsman wrestling with what on earth does this mean, and shoving in a question of relative, which may be misleading, Mr. Kennelly.
Well, as you've seen in the Khan judgment, which I shall take you to from the Court of Appeal very recently, the regulations were themselves subject to some criticism by the Court of Appeal.
Oh.
This is not the only bit of bad drafting you'll see today. But just to add to the confusion, under Article 8, despite what I've said about how family member is defined, in Article 8.5, which is on page MS 692, you see there's a reference to, for registration certificate to be issued to family members of union citizens, who are themselves union citizens, member states may require the following documents to be presented. But then in F over the page, and sorry, in E and F, there's a reference to cases falling under Articles 3.2a and 3.2b. Because those are not family members as defined, they're extended family members. Similarly, in Article 10, 1, E and F, over the page 694 and 695, issue of residence cards. Again, for the residence card to be issued, member states shall require presentation of the following documents, and they're listed. But in E and F, despite the fact that we're talking about the right of residence of family members, there's a reference to cases falling under 3.2a and 3.2b. Subject to that, I say, all the other references to family members in the directive, and there are many of them, refer back, as you would expect, to what is defined as family member in Article.
But forgive me, looking at Article 2 and 3 together, which are on 684 and 685, conveniently facing one another, is there a distinction between family members for the purpose of Article 2.2, which is defined in 2.2, and other family members for the purposes of 3.2a? Must be.
It must be, yes, indeed.
It simply won't work unless there is.
That's my point, and that's why I say that when you see family member, not other family member referred to in the directive, they must mean family members, because they have rights, very strong rights, arising from their status as family members, whereas other family members have far less protection, as we see in Rahman, the judgment as well as the Advocate General's opinion. The problem is that in a couple of places, although there's a reference to family members, there's another reference to other family members. But apart from those two exceptions, my friend may point to another one, but those are the ones I could find. The references elsewhere, I say, are to family member as defined. And that's important because of the procedural rights under the directive, which is what we're discussing here in this context. So if you go to Article 15, which is on page 700, MS page 700, you see that procedural safeguards, the procedures provided for by Articles 30 and 31 shall apply by analogy to all decisions restricting free movement of citizens and their family members on grounds other than public policy, security or health. I say family members there is as defined in Article 2. And then the actual procedural protection itself is contained in Article 31, which is on page MS 713.
Can I just ask, in 15.1, is the implication of that there is some provision in the directive under which free movement can be restricted on grounds of public policy?
Yes. Right. Yes, there is. And that's consistent with the position under the treaty.
Yes. So would it be open? Is there a possibility that 2.2 might be given a wide meaning, but the safeguards which you have emphasised the need for could be affected by means of the public policy proviso, presumably in appropriate cases? Presumably.
I mean, the problem with that is that the public policy proviso is very narrowly drawn. Since the Bouchereau case in the 1970s, I think, and subsequently, public policy under EU law is very narrowly defined. Yeah. And for those, and yes. So it may not, it may be too restrictive. I will check, but it may be too restrictive in order to provide the level of protection that is necessary and that we're required to provide under our international law obligations. Just to
yes, so I see it's Article 27.
Yeah, 27.2.
Yeah.
Yes. Yes, I'm sorry I've taken you back to the topic I thought you'd left, but I, it seemed worth just checking.
No, I understood the nature of the question, and I think the difficulty is that it's and this language in 27.2 has been construed consistently with the case of the court very narrowly.
Yeah.
Plainly, since it was used, there was a potential for abuse by member states seeking to evade their obligations by referring to these bases for exceptions.
Yes.
Yes.
Yes, and
but you say that. Sorry.
No.
But you say that family members in Article 27.1 doesn't include other family members.
That's correct. So the procedural safeguards in Article 31 on MS 713 apply to family members.
Coming back to Article 15, you say family members there is as defined in 2.2.
Yes.
Will you go on to explain, please, why the procedural safeguards shouldn't apply to an Article 3.2 failed applicant?
The first point, my Lord, is that the directive, in my submission on its proper reading, doesn't make provision for them. Family members are defined, and then the procedural protection of the directive extends to those family members only. And I say that reflects the fact that other family members under Article 3.2 are given far less protection under the directive. The member states, the full extent of member states' procedural obligations towards other family members is set out in Article 3.2 itself, which is that the host member state shall undertake an extensive examination of the personal circumstances, this is MS 6985, and shall justify any denial of entry or residence to these people. So that tells you what procedural protection Article 3.2 other family members have. And this is obviously in dispute, since my friends say that Article 31 does apply to other family members. There's no authority directly on that point, but I do rely on Rahman, at least indirectly. And if we could take up Rahman very briefly in Volume 4, tab 43. It's an MS, begins at MS 1585. And the judgment begins at MS 1609, and I wish to take the court to MS 1613. the court's answer to the question. This is one of the rare cases where the court's examining Article 3.2, as we said. And I've already, well, actually, this echoes what the Advocate General said previously. In para 19, you see the court now saying, skipping down 4 lines, the European legislature has drawn a distinction between the citizens' family members, as defined in Article 2.2 of the directive, who enjoy a right of entry into and residence, and the other family members envisaged in Article 3.2, whose entry and residence has only to be facilitated by that member state. A distinction drawn between a right of entry and residence and an obligation on the state to facilitate entry and residence. And over the page, you see at para 21, while it's therefore apparent that Article 3.2 does not oblige member states to accord a right of entry and residence to persons who are family members in the broad sense, the fact remains, as is clear from the use of the words shall facilitate, the provision imposes an obligation on member states to confer a certain advantage compared with applications for entry and residence of other nationals of third states on applications submitted by persons who have a relationship of particular dependence. And then, in order to meet that obligation, the member states must, and this is their procedural obligation, make it possible for persons to obtain a decision that is founded on an extensive examination and in the event of refusal is justified by reasons. Skipping down to 24, in the light of both the absence of the more specific rules in Directive 2004/38 and of the use of the words in accordance with its national legislation, Article 3.2, each member state has a wide discretion as regards the selection of the factors to be taken into account. Nonetheless, the host member state must ensure that its legislation contains criteria which are consistent with the normal meaning of the term facilitate and of the words relating to dependence used in Article 3.2, and which do not deprive that provision of its effectiveness. And then finally, at 25, skipping down 6 lines, the fact remains that such an applicant is entitled to a judicial review of whether the national legislation and its application have remained within the limits of the discretion set by that directive. This is not obviously express in Article 3.2, this right to judicial review, but it's here in the judgment, and this is what kind of judicial review is envisaged by the court. Now, my point is, if Article 31 of the directive applied to other family members, the court would have said so here. But they have not, and the cases that are referred to at the bottom of paragraph 25 are not Article 32 cases. These are cases drawn by analogy about procedural protection. They do not relate to Article 30, to the Article 31 and 32 of the directive. So, moving on to the regulations, which are in the supplemental bundle, tab 6. So this is the bundle from the last hearing.
The first supplementary bundle, rather than the second supplementary bundle.
Sorry, the first supplemental bundle, or supplementary bundle, as it's called. SMS, page 109.
One, 109.
109, my lord, yes.
(2006) regulation.
Yes.
First supplementary bundle.
Yes.
Not Supplementary Authorities, Volume 1.
No, it has supplementary bundle, SMS, as I say.
I think it was yellow.
Yellow one. Thank you so much. I'm sorry.
No, I also struggle with these. And I wish, if I may, to begin with Regulation 26. So if you go through the regulations to SMS page 126, you see the reference to appeal rights. We're now concerned here with the domestic legislation that will lead to my submissions on domestic construction. So appeal rights are in Regulation 26, SMS page 126. And you see that subject to the following paragraphs of this regulation, a person may appeal under these regulations, that's an appeal to the FTT, against an EEA decision. To find out what that means, what EEA decision means, I want us to go back to Regulation 2. Which is on SMS page 112. EEA decision means a decision under these regulations that concerns a person's A, entitlement to be admitted to the United Kingdom, which is the regulation which we are concerned today. But for the purpose of understanding the case law, it's useful to see the next subparagraph. An EEA decision also means a decision under the regulations that concerns a person's entitlement to be issued or have renewed or, and I shall refer to this later, or not to have revoked a registration certificate, residence card, document certifying permanent residence or permanent residence card. So the key language are the words concerns a person's entitlement. A decision under the regulation that concerns a person's entitlement to be admitted to the United Kingdom. And to understand the provisions themselves, could you turn please to Regulation 7, which is an SMS 115, headed family member. In 7, it says, subject to paragraph 2, for the purpose of these regulations, the following persons shall be treated as the family members of another person, spouse, civil partner, and they're listed then. The court can read down to D. These are obviously lifted from Article 2.2 of the directive. And then at 3, Regulation 7.3, one sees an important provision. Subject to paragraph 4, a person who is an extended family member, and we'll come to how that's defined in Regulation 8. But here it says a person who is an extended family member and has been issued with an EEA family permit or any of the other documents shall be treated as the family member of the relevant EEA national for as long as he continues to satisfy the conditions in Regulation 8 in relation to that EEA national and the permit, certificate or card has not ceased to be valid or been revoked. So once you are issued with the family permit, you're treated as a family member with the benefits that entails. So then 8, extended family member. And the court can read in 8.1 and 8.2 how the UK has sought to implement Article 3.2 of the directive.
You will say that the implementation here is valid?
Yes. And if one turns then to the question of issuing family permits to try and see whether there's an entitlement for these purposes, I ask the court then to turn to Regulation 12. And you have the point, which I've made in my submissions, that under 12.1, an entry clearance officer must issue a family permit to a family member. But under Regulation 12.2, an entry clearance officer only may issue a family permit to an extended family member if that extended family member satisfies the conditions in Para 1A. Sorry, the EEA national satisfies the conditions in Para 1A, and then the extended family member satisfies the conditions in 12.2b. And then in 12.2c, it appears in all the circumstances to the ECO appropriate to issue the family permit. So even if those criteria are satisfied, the ECO still has a discretion as to whether or not to issue the family permit. And then on 3, one sees the fetter on the ECO's discretion. It says he shall undertake an extensive examination of the personal circumstances of the applicant, and if he refuses the application, he shall give reasons justifying the refusal unless that is contrary to the interest of national security, which is the procedural obligation that I took you to at the bottom of Article 3.2. So, on the question of domestic construction, the question is there a right of appeal to the FDT against a decision refusing a family permit under Regulation 12.2? And that's the point in the Sala case. Now, we submit that an entitlement is something that a person has by right. And under Regulation 12.2, as I've said, even if an applicant can satisfy the respondent that he is an extended family member within the meaning of the regulations and satisfies the criteria set out there, all he obtains is the procedural right to a careful exercise of discretion as to whether or not he may enter and reasons. Once issued, of course, once issued with a family permit, he is treated as a family member and he may enter the UK, and that's in Regulation 11.
Once issued with the family permit, does the person in question have the entitlement to enter the UK?
We say no. Strictly speaking, we say no. I see how one could think that, looking at Regulation 11, because in Regulation 11, there's a reference to a right of admission to the UK, and in 11.2, it says a person who is not an EEA national must be admitted to the UK if he is a family member and he has a valid passport and an EEA family permit. And we know that once the extended family member has been issued with a family permit, he is to be treated as a family member. So once you have the permit, then you can get in under Regulation 11. We say that does not mean that you have been granted or a right has been created for you to enter the UK. That is merely the facilitation by the Secretary of State of your entry into the UK.
If somebody applies as an extended family member and the entry clearance officer says no, and there's a challenge to that, and the person says, I am an extended family member, if you look at the directive,
yes.
And if you look at all the circumstances, it was quite clear that any evaluation should have led to me being admitted. Couldn't he then reasonably add, so I'm entitled to be admitted?
We would again say no. We say that this is not a situation where, certainly the appellants have not before a situation where one can identify a class of people where one can say in advance that it would be disproportionate to deny them an EEA family permit. Therefore, in that scenario, one can say that because it would be disproportionate to deny it, they should be granted it. But in our submission, that would be a very unusual and unlikely construction. One would have to conduct a proportionality analysis to work out if the tribunal had jurisdiction at all. So,
well, the alternative construction is, of course, that they do have a right of appeal, because what they are contending for is just the sort of decision that my Lord has put forward.
that is the submission which I face.
It is the submission you face.
But dealing with the point my Lord put to me, we say it would be very odd if one had to conduct a proportionality analysis to work out if the tribunal had jurisdiction in the first place.
Not sure that was the point you were putting.
It isn't. No.
No.
Well, perhaps I'm trying. Well,
I think he was putting the point that I've just put, only slightly different language.
Well, then perhaps if I rephrase my answer, my Lord's point is that surely one can say that in relation to a certain class of people, one can say that in relation to a certain person, if it's disproportionate to deny them the permit, they have an entitlement to the permit. And if that's my Lord's point, which I hope I've understood, then my answer is the same, which is that we say that can't be right. You can't have to work out if it's disproportionate in order to decide if the tribunal has jurisdiction or not. The family permit evidences the family member's right. Doesn't the extended family member's position doesn't create a new right for the extended family member. But I have to take you to Khan before I sit down, because Khan is the most recent authority against me where we've had this debate, and it's only on the domestic construction point. And Khan is in the second supplementary volume of authorities behind tab 37.
SSMS.
SSMS 1055.
Familiar team of counsel.
Yes.
I'm sorry, I haven't found this yet.
SSMS 1055.
Yeah, but I haven't.
It's in one of the green volumes we got.
Yes, exactly.
for
It's a
today's
different one. Can you tell me which of the files of which of the 1, 2, 3, 4, 5, 6, 7 electronic files we have I should be looking in?
I cannot assist you. I don't have the
Well,
electronic.
you should be able to assist.
Well, my lady, then I will. It looks like this. It's
That's
supplementary
of no
authorities.
use to me at all. I want to know what it looks like on the screen, please.
Somebody please tell me the number.
It's really unsatisfactory. We should be looking at this at this stage, isn't it?
The unfortunate thing is we have SSBs and SSMSs and SMSs.
This is an SSMS.
This is SSMS, and I have had it earlier, but I can't now find it.
The appellants prepared the files, so I hope.
Yes. Well, I know you're on your feet, so you get the flack. But
No. It's my own.
somebody should have
We
put
all share
these together.
responsibility.
We should have insisted that somebody put all these together. It's not the second supplementary bundle that was there for the first hearing.
No, it's a new bundle of authorities which came in after the final submissions were lodged. So it'll be one of the last.
So what is the
It's
page
it's
reference?
headed final hearing.
Yes, that's right. So what's the page reference?
SSMS 1055.
Yes.
That may be the most enthusiastic
This is under
reaction
SM final.
this authority gets.
SM final, as far as we're concerned.
SM final.
Thank you.
So, in this case, the very same question of jurisdiction arose, but it was in relation to Regulation 17, which concerns residence cards. Nothing turns on that. We have family permits, in this case, residence cards in the Khan case. But if I could just take you straight away to the analysis, because the two problems for me begin at para 37, at SSMS 1064. Because my Lord Justice Irwin made 2 points. One, a contextual point, and one, a point about the construction of the language itself. The contextual point is at para 38. Although he talks about a difficulty for me in para 37, that is potentially an error in the drafting. It's not material for your purposes. The contextual problem for me, according to the Learned Lord Justice, begins at 39. He says there, Schedule 1, paragraph 1 to the regulations has gone through more than one evolution. At the date of the decision, the wording was as set down in Annex 2 to this judgment, and I'll take you to that, provided that the following provisions of the 2002 Act have effect in relation to an appeal under these regulations to the FTT as if it were an appeal against an immigration decision under Section 82(1). And he says it follows that Section 84(1) had effect as if it were an appeal against an immigration decision. So Section 84 is brought in where there is an appeal under the regulations. And he relies on the fact that Section 84(1) provides for the grounds that may be brought in such appeals. And in 84.1d, one of the permitted grounds is that the appellant is a member of the family of an EEA national, and the decision breaches the appellant's rights under the community treaties in respect of entry to or residence in the United Kingdom. And he refers to the appellant's argument at 41 that the phrase member of the family covers both family members and extended family members. He says the employment of the term a member of the family means draftsman had avoided the term of art and adopted a wider phrase. This gives, he says, real support to the appellant's contention. Now, my first point here is that this sections 82 and 84 are of no assistance in interpreting the 2006 regulations. And you see that if you go to the end of this judgment and actually look at the legislation which the Court of Appeal helpfully annexed to this judgment. You go to the very end of the tab at SSMS 1078.
At the end of the day, doesn't Lord Justice Irwin and also Lord Justice Longmore simply focus on the ordinary meaning of the words concern and entitlement?
But I think Lord Justice Irwin said this gives real support to the appellant's contention. And later on, he says, against this background, I think I need to deal with it because he said...
Right.
You're on paragraph 41 of Lord Justice Irwin's judgment.
That's right, my Lord.
You're coming, presumably.
I am. But before I leave that, I just want to take you to the legislation to make good my point that it doesn't
Right.
assist. At the end of the tab, at SSMS 1078, you see what the schedule to the regulations actually says. And it says the following provisions of or made under the 2002 Act have effect in relation to an appeal under these regulations as if it were an appeal against an immigration decision under section 82.1 of that Act. But that applies in relation to appeals under these regulations. So only where there is a valid appeal under these regulations do these sections from the 2002 Act carry across. And then if you look to see what they actually say, if you skip back in that same clip to page SSMS 1072, you see section 84. And section 84.1 provides for the exhaustive list of grounds that may be brought against an immigration decision. And sure enough, at 84.1d, one sees the ground referred to by my Lord, and it's that the appellant is an EEA national or a member of the family of an EEA national, and it breaches his rights. But as I said, again, that only applies if there is actually a valid appeal before the regulations. It doesn't tell you what kind of appeal is permitted. But more importantly, we accept, as we always have done, that extended family members may have appeals to the FTT in certain contexts. An extended family member, for example, who's been issued with a residence card has a right of appeal if that residence card is revoked other than in the conditions set out in Regulation 7.
Well, we're talking about entry, aren't we, Mr.
Well, we're talking about entry.
Yeah, but your point is that means that references to such a person having a right of appeal don't tell you which right it might be.
Exactly.
Is that it? All right.
And even if the Lord Justice is right that this envisages appeals by extended family members, we accept that in certain circumstances an extended family member can bring an appeal where, for example, as I say, he's been granted a residence card and it's been revoked other than under the conditions in the regulations. Turning back then to the judgment itself in paragraph 41, and moving on to the principal point, the meaning of the language. And you see what the learned judge says at para 45. He says, not only does the context favour the appellant's interpretation, but it's the more natural meaning of the words. An entitlement is subtly different from a right. The natural meaning of the latter is something inherent and existing. The natural meaning of an entitlement is a benefit which is obtained or granted. Moreover, a decision which concerns an entitlement appears to me naturally to include a decision whether to grant such an entitlement. And that's precisely what the Secretary of State must do in a case such as this. in my submission, the distinction between right and entitlement, which Lord O'Serwin draws, is unsustainable. Because if in the context of Regulation 2, an entitlement means a benefit which is obtained or granted, and then that would apply equally to family members who obtain family permits and residence cards and so forth. But if they satisfy the relevant criteria, they must be granted the card or permit. The grant to them doesn't depend on any exercise of discretion. They have a right to that, subject to satisfying factual conditions. We say that entitlement here means something as of right, and not something which is subject to the exercise of a broad discretion on the part of the Secretary of State, or the EOC in this context.
You're not entitled to have the discretion exercised properly.
Yes, and you're entitled to have the discretion exercised pursuant to the requirements in Article 3.2.
That would give you a right. That would simply give the person a right to judicial review rather than an appeal on the merits to the immigration judge.
It wouldn't give you any right to entry in itself.
It wouldn't give you any right to entry.
That's the point. It gives you rights to judicial review, procedural protection, a reasoned decision. It does not give you a right to entry. You only have a right to entry at all once the Secretary has exercised the discretion.
But once he has, you are entitled to enter, aren't you?
Well, that's the point of
So
discussion.
is the decision about your entitlement to enter, or isn't it?
We say no. Your decision
We know you say no, yes.
But I mean,
that's the point.
You can almost reduce it to that.
Yes, exactly. And we say that stretches it too far. The language doesn't allow you to make that leap. And the learned Lord Justice said the word concerns does allow you to make that leap. It's broad enough. But we say, again, no, because at no point is the EOC considering whether the person has a right to entry or an entitlement to entry or not. For a family member, the question is, we know he has the prima facie right. Has he established the factual conditions? That's different. For an extended family member, it's within the gift of the EOC, subject to the fetters on his discretion, which we have discussed. Now, there's a further argument made by the appellant relying on the enabling power under Section 109 of the 2002 Immigration Act. I'm not going to take you to that. In the time available, you have my submissions on the point. It was dismissed. That same argument was dismissed by the Court of Appeal in Cannes. And the next question, of course, is that if you're with me on the domestic construction, it's still said that that construction is contrary to the principles of effectiveness and equivalence under EU law, and that judicial review provides insufficient protection to extended family members in this context. It's now 6 or 7 minutes past my time. On the EU law issue, there are a large number of authorities, and a large number of points are put to me. If I was to take you through those now, I would eat significantly into the time of my learned friends. So I'm in the court's hand.
Well, you've put quite a lot in writing, have you?
We have.
Yes. So you can rest assured that both has been and probably will be read again, depending on the view that we take of your domestic construction point, of
Indeed.
course. Yeah. Yes.
Thank you. Unless I can be any further assistance.
Thank you very much indeed. Mr. Moomin, do you follow? Oh, sorry. Wrong way round. I'm very sorry, Mr. Lask. Yes, Mr. Yes, Mr. Campbell.
My Lords, on behalf of the Quorum Children's Legal Centre, I propose to make submissions on Article 2.2. I know that our submissions originally started off focusing principally on the Article 3.2 question, but that's because the way the situation was at that time. In order to ensure that time is used effectively, I think what I will do is focus on the Article 2.2 question and leave our position on the article, on the jurisdiction question to be dealt with really by way of the written submissions which you already have. My Lady, my Lords, we say that all children of EU nationals or their spouses or partners are covered by Article 2.2, provided only that they're aged under 21 or are dependents. There are no other conditions attached by Article 2.2. So consistently with what is set out in our written case, we say that Article 2.2 covers not only biological children, it also covers children who have become part of that EU nationals family, whether through adoptions, which are recognised in the member state in question, or through other similar arrangements which have brought about a parent-child relationship, including arrangements such as kafala or de facto adoptions, whereby the EU national or his or her spouse or partner has acquired parental responsibility for the child in accordance with the legal traditions of their own country. This is in our written case at paragraph 2. I'm not going to go through the written case that you have. If we're wrong about that, we say they fall within Article 3.2. So that's the second submission. The third submission is that such children are entitled to a full right of appeal involving a full examination of the facts and circumstances to challenge any proposed measures relating to their rights of entry or residence, and not limited merely to the judicial review as understood in the United Kingdom. That's a third submission, which I won't have time to develop. These questions may involve a reference. You're already aware of the reference in the case of Bangor, and I think you're already aware that there's a hearing listed on 17th of January in that case. Dealing with the Article 2.2 question, the focus of the respondents' submissions has all been to emphasize adoption. This is the wrong way of looking at it. Article 2.2 has an autonomous EU meaning. And perhaps if we take up the directive, which is at MS 684 for these purposes, and that will assist the understanding of my submissions. The respondent says that adopted children are in fact covered by Article 2.2, but only if that adoption is recognised in the relevant national member state. The language simply does not say that. It says simply this: family member means A, the spouse, B, partners, etc., C, direct descendants who are under the age of 21 or are dependents and those of the spouse or partner as defined in point B. It contains no qualifications such as, or such other direct descendants as are understood to be such in accordance with national legislation. The directive is capable of referring to national legislation. It does so in 3.2, for example. There is no such restriction in relation to 3.2.2. This is because these words are intended to have an EU-wide meaning consistent with Article 7 and Article 24 of the Charter. And Article 7 is, of course, the analogue of Article 8 ECHR. It matters not whether we talk in terms of nuclear family or the closest family members, as Advocate General Bott did. That's precisely our point. We say, yes, indeed, this is talking about relatives in the direct descending line and relatives in the direct ascending line. Direct descending and direct ascending. This is your nuclear family. These are the closest members. And so all children, we say, fall within Article 2.2. Question arises then, how do you define whether they're children in the direct descending line? The words of Article 2.2 do not impose any restriction in that regard. The approach that should be adopted, therefore, consistent with our written submissions, is an approach which complies with the UN Convention on the Rights of the Child and Article 8 of the ECHR, or Article 7 of the Charter. In other words, what this directive is doing is, it is saying, it is putting forward what are really what, if I can use this phrase, the constitutional rights of EU nationals, EU citizens. It's that important. It is not to be interpreted by reference to the Hague Convention. It is a freestanding document which sets up those, what I call the constitutional rights of EU citizens to move and reside freely across member states. And we know from the constant case law of the Court of Justice that the terms of this directive must be interpreted in a way which do not discourage the free movement. That point was already there on paper. It must also be interpreted in a way which does not bring about discrimination as between one type of child and another. I'll come on to the concerns that will arise in a moment. So it may be that in one family there are children who are blood children, as it were, biologically descended. It may be that there are children who are adopted, who are in accordance with procedures recognized by the member state. It may be that there are children who are de facto part of the nuclear family, and everybody recognizes them as such, and it is in their best interest as such. We say this Article 2.2 protects all of them without distinction. For the reasons that I mentioned, the imperative not to impose impediments to free movement and the non-discrimination principle in Article 2 of the UNCRC, which, unlike the Hague Convention, is recited in the recitals to this directive. And it's as simple as that. Now, that, however, doesn't mean that that may give those children the right of entry, entitlement. A similar parallel can be drawn with marriages. If a union national is married to another person, provided only that the marriage is shown to be a marriage of convenience or is in some way an abuse of EU law rights, that marriage is to be recognized for the purposes of Article 2. And we say, in what sense are children any different? They are not. In principle, that is the position. What may happen on the facts of a particular case is another matter, but in principle, that is the position. And the concerns, and I'll get straight onto those and then come back to making some points about adoption in a moment. The concerns, however, are these. Well, what if somebody seeks to bring in a trafficked child or a bored child? We say that is a different question. That is not an Article 2.2 question. Article 2.2 is simply defining the category of persons who are entitled, who have the right, in principle, to enter. The right in principle to enter. Now, there are a number of safeguards. Firstly, they're going to have to prove that family relationship. I'll come to the Commission communication document in a moment. So they're going to have to prove that. And if there is reason to think that actually there are concerns about this particular marriage, for instance, or this particular relationship with this child, for instance, there are remedies in Article 27 and in Article 35. Article 27, you've already been shown about the public policy constraint, and that is at MS 709. Article 35 is at page MS 716.
Well, hang on. What about 27.2, Mr. Gill? Public policy must be based exclusively on the personal conduct of the individual. Now, the child won't have done anything wrong.
It won't be on the child, but the person's actually.
It's the child's
Look at the
entry.
wrong
It's the child's entry which is in question, you see.
Yeah.
Parents have no problem.
My Lord, I would suggest that Article 27 is perhaps broad enough to cover the position of a child who has been brought in abusively by the conduct of a parent.
Well, what does the individual concern mean? To whom does that relate?
Must be the person who's trying to get in, mustn't it?
Either it could be the person, the child who is getting in, or it could mean the person with whom the child, in whose custody the child in effect is. But even if there is a concern about 27.2, 35 provides a clear answer. Member States may adopt the necessary measures to refuse, terminate, or withdraw any right conferred by the directive in the case of abuse of rights, fraud such as marriage of convenience, and so on. So there are provisions available within the directive itself for member states to ask for evidence of the claimed family relationship, and then, if there are concerns, to investigate them, and if necessary, refuse. They may, at that stage, be a large number of considerations that have to be taken into account, including the extent to which there is recognition or non-recognition of any foreign document. This is why if I turn to the Commission communication document, which is in the same bundle, at page 725, 724, 725, it is framed at the bottom of 724 in the way that it is. It says, without prejudice to issues related to recognition of decisions of national authorities, the notion of direct relatives in the descending and ascending line extends to adoptive relationships, or minors in custody of permanent legal guardian. Foster children and foster parents who have temporary custody may have rights depending upon the strength of the ties. There is no restriction as to the degree of relatedness. It doesn't have to be a blood relative. Doesn't have to be a particular type of adoption. National authorities may, however, request evidence of the claimed relationship. And those words, without prejudice to issues relating to recognition of decisions of national authorities, are simply saying this. They are recognizing that there may well be issues that arise for a member state when it is faced with, let's say, an Algerian court order. It is saying that this communication is saying, well, we recognize that you may have decisions to make in relation to that. We recognize that in your own national law, you may choose not to recognize that Algerian court document for what it says it is. But without prejudice to that isn't the end of the story. You still have the notion of direct relatives in the descending or ascending line adopts, in principle, to these type of relationships.
I don't know if it may help you, Mr. Gill. Are you going to bring us to a passage at MS 735? It's under the heading marriages of convenience.
Yes.
And the point of interest is that in the second paragraph under that heading, we're told that the definition of marriages of convenience can be extended by analogy to other forms of relationship contracted for the sole purpose of enjoying the right of free movement, such as fake adoption and the like.
My Lord, yes, I'm grateful, but that whole page, in fact, is relevant. But can I start at page 722? Because this communication was thought to be suggested that this is just a commission view. But look to see in what circumstances it has come about. It says on page 722, the Commission adopted its report on the application of the directive. They looked at a comprehensive overview of how the directive is transposed into national law, how it is applied in everyday life. They noted, next paragraph, the result was transposition was rather disappointing. They noted in the third paragraph that there are problematic issues in transposition or application. The intention was then to provide some guidance. This intention was welcomed by the Council and the European Parliament. And then it goes on to say, fourth paragraph, this communication aims to provide guidance to Member States on how to apply the directive, with the objective, at the end of that paragraph, of bringing a real improvement. And it is therefore an important communication which sets out what is intended by EU institutions. It has not been contradicted by the European Parliament or by the Council, and there is no case law of the Court of Justice which contradicts it. That's the important point. There is, whether there's any case law which supports it is another matter also. The case law simply doesn't confront this issue. The closest we have is Rahman, and you've been taken to those passages where Advocate General Bott does not in fact rule out the argument that we are putting to you at all. So the passages which are on page 735, I'll take as read, and I'm grateful to my Lord for drawing attention to them. But you might also want to look at 724 under the heading of spouses and partners at 2.1.1. It says marriages validly contracted anywhere in the world must in principle be recognized. In principle. Talks about forced marriages, then talks about polygamous marriages, and so on. So and when one reads the whole of this and reads 2.1.2 in the context of the whole of the document, what one sees is the Commission basically saying, provided only that you fall within this category in 2.2 of being a relative in the direct ascending line or the direct descending line, and or a spouse or partner, that is the nuclear family, those are the closest members, those people automatically have the right to come in, subject to proof of the claimed family relationship. So what will happen in practice? Somebody comes along at a border and says, here I am with this child, and I've got an Algerian court document which says that this child is mine. The person, the immigration officer, the relevant officer, will investigate that situation, will probably need to check carefully in the absence of birth certificates and so on, whether this child is in fact this person's child, will then need to make inquiries, but those inquiries will then have to take place in the normal way. They may involve saying, well, we're not going to, at this stage, recognise the child's right of entry under Article 2.2, right of entry, which is different to whether it is ultimately in the best interest of the child to remain in this jurisdiction. We won't make a decision on that right of entry at the moment until we investigate this. There will then be a full process of investigation. It may involve inquiries with Algeria. It may involve exactly the sort of things that occurred before the first-year tribunal. Said, well, what did the Algerian judge look at or did not look at? Well, even if there are defects in that process, even if we don't recognize it, can we actually say, adopting an EU-wide definition for the purposes of ensuring that the aims of the directive are complied with, can we say this actually is a family member? This is a direct descendant for the purposes of the directive? Because this is a autonomous phrase that is being used in this directive. So far as 3.2, I have a few more comments to make in relation to that.
Just before we leave the guidelines, just very quickly, Mr. Gill, page 730, the Commission, MS 730, the Commission say halfway down the page that provisions granting freedom of movement must be given a broad interpretation.
Yeah.
And they cite two cases. I don't think we've looked at either of them, but Kempf is in our bundle.
Yes.
The supplementary bundles we've got for today's hearing. I don't think we had JIPA.
I didn't put that. Kempf is there because we asked for it. It's an our written case.
Yeah.
But I didn't.
Yes, it's a very early case, just saying in general terms that free movement of workers provisions should be interpreted broadly.
Yeah.
JIPA, I don't know what that's about.
Yeah. But this is a standard approach.
Yeah.
You've got to interpret this Article 2.2 broadly. Questions of abuse are perfectly capable of being dealt with. I know other questions may arise. One of those, the respondent says, well, only adoptions that we, the United Kingdom, choose to recognise are within Article 2.2. But this is, as I've said, not what Article 2.2 says, and it seems to actually give rise to great disparity of outcome across member states. And what the EU legislature is getting at is, we know that there are going to be disparities in how states recognise adoptions, but what we are trying to do, they don't even use the word adoption in 2.2, what we are trying to do is to define what family member is for the purposes of ensuring that free movement is promoted. The respondent's construction would in fact have very problematic consequences. For instance, what it could give rise to is an example such as this. Consider the case of a French national, his American wife, who have one child who is of American nationality. They live in France. They move to Algeria and live there for a year or two. Being of Muslim heritage, they legally adopt an abandoned Algerian child in accordance with Algerian law, and promise to bring that child up in Muslim tradition, which prohibits adoption. They then decide to move to the UK. On the Secretary of State's analysis, the Algerian child simply could not enter the UK through EU law rights with the rest of the family. There is going to be a delay. There is going to be some sort of impediment. The first child, who's of American nationality, can come, but not this other child. Now you can conceive of a range of other problems also that could arise. A British gay couple who have adopted or been appointed as legal guardians or are fostering a child from Germany could not travel to countries such as Lithuania, Hungary or Romania because those countries don't recognise adoptions of gay persons or even such formalised gay relationships. The same point applies to a dual Colombian, in other words, non-Hague Convention, and Spanish gay couple who have fostered a child and who wish to move to travel to Lithuania, Hungary, or Romania within the EU itself. This will give rise to great disparities as between one type of child and another. Now, we say this is a matter which should be determined at an EU-wide level with minimum requirements. The respondents' emphasis on adoption is, we say, completely off the mark. The language of adoption is not the language we should be talking about here. What we're talking about is adoption-like arrangements, not adoption. The mere fact that there are Western law, Roman law traditions whereby adoption is recognized only if certain things happen. The mere fact that there are international agreements such as the Hague Convention on Inter-Country Adoption, which are talking about adoption, all of these are completely irrelevant with respect. Well, irrelevant is too strong a phrase. These are not what determine the outcome of Article 2.2, because this is not a case about adoption as such. This is a case about kafala. And this is a case about family members for Article 2.2. And Article 2.2, child, can be someone who's adopted, can be someone who is party to a kafala relationship or a de facto relation, provided that it is proved. And if you don't have the relevant documents to prove it, you may be subjected to pretty rigorous examination, you the parent. And you may well have to say, well, this child has actually lived with me. I can show you all the records of how I've gone to the child's school in Algeria over year after year. Here are photographs, here are this report or that report. I may not have a court order, and if I have a court order, you may not recognize it, but are you seriously doubting that this child is, to all intent, is my child? Now, all of that is subject of actual examination. Questions of abuse are therefore perfectly capable of being dealt with under 2.2 and 35.
Sounds more like the comprehensive examination required under 3.2, Mr. Gill.
My Lord, for a marriage of... If you suspect that there's a problem, you have to carry out that examination. And your Lordship says to me, comprehensive examination. Well, you'd have that with a suspected marriage of convenience anyway. So why not with a suspected parent-child relationship, which is of convenience, which is designed simply to abuse EU law rights? It's not the question, it's not the fact that there can't be an examination. There can be an examination for 2.2 purposes, just as there can be an examination for 3.2 purposes. What Article 2.2 is saying is, with what I'll call the nuclear family, those in the descending and ascending line, the direct descendants, these people come in automatically, provided you can prove it. Now, proof sometimes is very easy. Proof sometimes is, here's a birth certificate. Proof sometimes here is, in accordance with your national arrangements, you recognize these adoption orders, don't you? Here's an adoption order.
Proof of a kafala?
Proof
order
of kafala, which you may...
what has lain behind the kafala order, Mr. Gill?
That may
if
have
you're
to
saying
be investigated.
the kafala order is enough for 2.2, then
no, I didn't say a kafala
got...
order is enough for 2.2. What I said, an adoption order is enough for 2.2. This is what I think one has to really...
I'm looking at paragraph 32 of your case, Mr.
Yes.
Gill. Anyway, there we are.
Paragraph 32 does not dispute the possibility that there could be an examination. We are not saying that someone who is a child of a kafala relationship is automatically entitled to walk in without some examination. There has to be proof of the claimed family relationship.
Leave kafala out of it for the moment, supposing it hasn't got that label, but you've got a child who's been living with the parents for the last 5 years.
Yeah.
Are you or are you not entitled to ask under what circumstances, safeguards and conditions the child came to be assimilated into the family?
My Lord, yes, but my Lord, there is no reason why the national authority should not say, well, you say this child's been living with you.
No, supposing there's no doubt about that. We've got the school records. Everybody knows the child's been living with the couple for the last 5 years. My question is, which I think is the question behind most of this, how far are you entitled to go, if at all, into discovering how the child came to start living as a de facto member of the family? For example, are you entitled to find out whether her true natural parents ever really consented? Or are you to say the de facto position is perfectly clear, she's a member of this family, freedom of movement triumphs?
My lord, I'm saying the latter. So far as the concerns about what is concerning your lordship, so far as those concerns are concerned, that doesn't mean to say that national authorities cannot make inquiries. There are other mechanisms available for that to be dealt with. All we're concerned with is Article 2.2 entitlements.
But you are saying that it's irrelevant to the Article 2.2 question, so long as there is a sufficiently established factual relationship.
That's right.
It's irrelevant how it came about.
Yeah, that's right. I mean, otherwise, who knows where that inquiry would end?
Well, it would take you into Article 21 of the UNCRC, wouldn't it?
Well, Article 21 is only dealing with adoption.
You say that's only adoption. Okay.
And it is after Article 20.
So basically, freedom of movement triumphs so long as you've got a de facto family.
That's right.
Got it.
And so far as if you're going to adopt a system of adoption, you've got to do the stuff that is set out in Article 21. If you're not going to adopt systems of adoption, then the systems that you adopt, such as kafala and so on, may come under scrutiny in other countries. But what Article 2.2 is concerned about are de facto relationships.
Yep.
Secretary of State...
Mr. Gill, I'm afraid you have exceeded your half hour. You started late, but I've been keeping tabs on your time.
Oh, I do apologise.
No, you mustn't.
I expect it's my fault, Mr. Gill.
Yes, you hadn't exceeded it until my lord started asking you questions. That I can say. So I'm sorry, I think because we're very tight for time, and we'll have to try and find some way. Mr. De Mello may be able to do with slightly less time than he's been allotted. Do you think you could do that?
Yes, sir.
And would you be able to allow Mr. O'Neill his half hour as well?
I'm pretty confident.
You're pretty
Probably
confident
be
you will. So perhaps if you just drew your remarks to a close and then we'll adjourn. If Mr. De Mello is kind enough to give way, that's very
My lady, I think the core points are essentially made. The mere fact, lastly, I suppose I can just say, the mere fact that there are alternative mechanisms for entry outside of EU law, which some people may be able to utilise, is nothing to the point. My lady, leave it there.
Thank you very much, Mr. Gill. Just before we rise, obviously the Khan decision came after everybody had put in their submissions, even after yours, Mr. Kenway. Obviously, we will have some. We've had your submissions on it, but if anybody wanted to put in written submissions about that decision, I think you should be given the opportunity of doing so within 7 days.
Lady, also, not wishing to push my luck, but if I am to keep to my half hour or even go under it, I have one case which postdates the submissions, which I was perhaps going to suggest over a working lunch the court might wish to have, and I'd say which passages on that. And it would save a lot of time. It's all about effectiveness, in fact.
Yes, which is the case?
It's I have a case here. It's called
you've got
Pushkar, and it's Advocate General's Cocotte from paragraph 46 to 51, and the court's judgment from paragraph 57 to 62.
Sorry, Advocate General?
Advocate General Cocotte, paragraph 46 to 51,
yeah.
And the court judgment, paragraph 57 to 62.
Thank you very much.
Obliged, my lord.
entity.
Yeah.
Thank you.
Well, we'll look forward to hearing from you at 2 o'clock, Mr. O'Neill. Court is now adjourned.